Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to do some serious geek out material here. We're going to talk about the common use test, and then we're going to talk about a newer common use test that we're seeing pop up in some opinions and the dangers it has, but more importantly, we're going to talk to all of you about how to effectively combat it. Because anytime we see these ludicrous arguments that are used to support gun control legislation, it's just a matter of time before they start popping up in all other jurisdictions. So today, let's geek out for a little bit and let's have a discussion about the new and very dangerous common use test and how to combat it. Okay, we're going to be talking predominantly about two cases today. The first case is a case called Oregon Firearms Federation v. Kotek. That is a challenge to Oregon Ballot Measure 114. That is essentially where this new rule comes from, and we'll talk about that in a moment. For those of you who haven't geeked out on Ballot Measure 114, we've done a bunch of videos on it. You can check out any of these videos here and find out what a horrible pile of crap this legislation is. The other case we're going to talk about is a case called Hartford v. Ferguson. It's a case that was a challenge to Washington's assault weapon ban, which was passed through House Bill 1240. It was unsuccessful in getting an injunction, and the judge there kind of planted the seeds, which then grew into the tree of disaster that Judge Ermagert authored in the Oregon case. Now, quickly, we know that when we're talking about banning outright certain platforms of firearms, what's at play is the rule called the common use test. And the common use test does not come from Bruin, although the Bruin court absolutely positively affirmed the rule. It actually comes from the case of District of Columbia v. Heller. And in a nutshell, what it says is there is a historical tradition that will allow government to restrict access to firearms which are deemed both dangerous and unusual, okay? And so when we start talking about banning modern firearms that are in circulation for all sorts of lawful purposes, including self-defense, then the rule of law is, no, you just don't get to do that. These firearms are in common use. Now, we have all sorts of crazy legislation kicking around the United States right now. Most of it is a byproduct of what we've called the post-Bruin tantrum, where a lot of these very blue states just completely crapped their pants after the Bruin opinion, and they basically said, oh yeah, watch this, and they're writing more restrictive, more unconstitutional gun laws. When we see challenges to these laws, if a court were to actually apply the common use test as authored by Justice Scalia, well, those who are advancing gun rights would win every single one of these. Now, they used to have this two-part balancing test where judges could just put their thumb on the scale and always come out in the favor of civilian disarmament, but the Bruin court did away with that two-part balancing test and really forced the courts back into historical analysis as to what we can and cannot do. So, in order to work around the common use test, where this all comes from is first a judge in Washington State, Judge Robert J. Bryan, when he denied the motion for the injunction on House Bill 1240, Washington's assault weapon ban in the matter of Hartford v. Ferguson, he just so happened to mention the following. The burden on HB 1240 on armed self-defense is slight. The proponents of HB 1240 have pointed to evidence that assault weapons are rarely used for self-defense. So you take that tiny shred of dicta, you then drive it down the freeway to Portland, Oregon, you get it in front of Judge Karen Ermagert, a Donald Trump appointee, on the challenge to Oregon Ballot Measure 114, and when she finds all portions, including the magazine ban there, to be constitutional, she basically says the plaintiffs here have not demonstrated that these are in common use for self-defense. So we've gone from the common use test to the common use for self-defense test. Now, that is a new rule of law, but we've already begun to see it pop up because now you circle back to Washington State and you see that our Attorney General is now citing Judge Ermagert here in the state of Washington saying, well, the standard is can the plaintiffs establish that these are in common use for self-defense? If they can't do that, then the Second Amendment doesn't even protect these types of firearms. That is actually their argument. Now, it is a very dangerous argument because you can imagine how expansive this could get. It's a very dangerous argument because judges who are absolutely hell-bent on civilian disarmament are going to buy in on this. And so we need to start learning how to counter this argument. Now, enter the plaintiffs representing Mr. Banta in Banta v. Ferguson, the case that's now going on in the Eastern District of Washington, because after our Attorney General filed the supplemental memorandum saying, hey, look at what happened down in Oregon. The judge down there absolutely got it right. She's got this whole new rule of law, and this is what we should be operating under here in Washington State. Plaintiffs' counsel did a fantastic job of absolutely shredding that argument. I'm going to share with you some of the pleadings so that you can understand nationwide, this is how you pummel this argument into submission. This is how plaintiffs for Banta summarize the state's position. According to the state, whether firearms are commonly possessed is irrelevant. All that matters, says the state, is how frequently people use, by which they seem to mean fire, them in self-defense situations. This is a remarkable claim, given that the Supreme Court has declared the frequency of possession, not of firing, let alone firing in actual confrontation, dictates whether a firearm is in common use. Plaintiffs' counsel also stated, indeed, Heller held explicitly that the only arms that may be banned, consistent with historical tradition, are those not typically possessed by law-abiding citizens for lawful purposes. And what the Oregon court basically did was take an incredibly perverted interpretation of the Heller rule, which is that we cannot ban firearms that are in common use for self-defense and other lawful purposes, and now interpreted the rule to say we can ban firearms unless they are in common use for self-defense. That is the rule that Judge Ermagert has carved out. Plaintiffs respond to it this way. The pertinent Second Amendment inquiry is whether arms are commonly possessed by law-abiding citizens for lawful purposes today. And the state of Washington here has actually argued that the Bruin court actually in many ways did away with the common use test, which is absolutely intellectually completely dishonest. Plaintiffs attack it this way. But in doing so, the court hardly cast aside Heller. To the contrary, the in common use at the time language comes directly from Heller. Lest there be any lingering doubt, Bruin concluded that the people have a right to carry handguns outside the home for self-defense without ever asking how frequently they fire them in actual self-defense situations. And that essentially is what the state of Washington is arguing, is that the data that we need to look at now is not the number of people who possess them, but the number of people who have used them in lawful self-defense situations. I'm not making this crap up, okay? This is what Judge Ermagert ruled, and this is what the state of Washington is running with. Plaintiffs counter it with this. The Second Amendment protects the right to keep and bear arms, not just to fire them at would-be attackers. Individuals keep arms by keeping firearms in their home at the ready for self-defense. Plaintiffs also point out how frequently law-abiding citizens keep versus carry handguns or fire them at ranges versus at attackers is therefore legally irrelevant, as an individual lawfully uses her firearm every time she does any of those things. The state's contrary argument is not so much an effort to apply Bruin as to rewrite it. And what the government actually is trying to do here is shift the burden and say, you know what? It's not us that have to demonstrate that these firearms are not in common use. It's the plaintiffs that have to demonstrate that they are in common use for self-defense. But plaintiffs' counsel correctly points out, what that means here is simple. Given that 6 to 8 million Americans lawfully possess at least one AR platform rifle, the state bears the burden of showing that the typical member of this enormous population does not, in fact, keep such arms inside their home or carry it outside their home for lawful purposes like self-defense, but instead typically keeps and carries such arms for unlawful ends. The state has not even tried to do so. And one of the reasons the state has not tried to do so is, according to the plaintiffs, if you take a look at all the number of semi-automatic rifles are owned, and then you subtract from that the people who have actually committed crime, the remaining portion of lawful AR owners is the remaining 99.999995%. And of course, the state here, as it does in many other areas, is trying to say, but look at these firearms are used in these horrific incidents, which they are. Not nearly as frequently as what handguns are used, but I digress. But the plaintiff's counsel here correctly circles the court back to the true issue at hand. Of course, none of that is to deny that some people have put these arms to unlawful, indeed awful ends. But the fact that handguns are the overwhelming choice of criminals did not alter Heller's conclusion that handguns are protected because the typical owner of such arms typically possesses them for lawful purposes, including self-defense. So too here, the state's emphasis on the horrific crimes that a small number of perpetrators have committed using firearms it now labels assault weapons does not change who the typical owner of such an arm is or how they are typically used. And it really is as simple as that. Now, plaintiff's counsel tries to really tighten it up, put a little bow on it this way. The court can and should end its analysis here. Bruin makes clear that dangerous and unusual is a conjunctive test, as the court explicitly stated that firearms must be highly unusual in society at large to fall within the historical tradition of restrictions on dangerous and unusual weapons. And then, of course, there is the argument, but the founders could have never foreseen the technological advancements and the rise of mass shootings using these firearms. And so all bets are off. But no, that is not true, because that has been contemplated by our founding fathers, as the plaintiff's counsel correctly put it. And Bruin makes clear beyond cavil that even if past laws prohibited the carrying of certain arms because they were considered dangerous and unusual weapons in the past, such laws would provide no justification for laws restricting arms that are unquestionably in common use today. So, the in common use for self-defense is one of the most intellectually dishonest arguments made by those that advance civilian disarmament. And let us remember that this is a laundry list, a long laundry list of disingenuous arguments that has come from this movement. The case, once again, if you want to read more of the pleadings, is Banta v. Ferguson. We're going to put the links for it down below. It's a challenge to Washington's assault weapon ban, House Bill 1240. It's a response on a motion for an injunction. I need all of you, though, to very carefully understand what this new test is, the ridiculous nature of it, the fact that it is not grounded in any law or any reasonable interpretation of case law, but this is how those that are advancing civilian disarmament are going to try to continue to ensure that these laws remain in effect. Listen, if you have any more questions about the new common use test, or anything else related to what's left of our Second Amendment rights. Now, you guys should know how to contact Washington Gun Law by now, but if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.